Today's episode, let me talk about my thumbnail. Well, I kind of introduce in the video. I made a pre-recorded video because I kind of like this style of I chat with you a little bit before and then play the video and chat with you a little bit after. That way everything stays on track. And this one was intense. So I've been working on this video for a while. This is the first one in a series that's about the motion to dismiss that Stephanie Jones filed against the counterclaims of Jennifer Abel. So, as you know, this was about 2 weeks ago. Judge Liman granted almost the entire case to be dismissed. Now, only one was with prejudice. The rest were without prejudice, which means the ones without prejudice, she can try to cure, resubmit, and he will reconsider it all again. The ones with prejudice, that's usually it. They can't just cure it. He tends to make the decision to do too much with prejudice, which I find a little crazy. He did that to Wayfarer as well. Almost all of their stuff was with prejudice. So at least this time, he did give her another chance for most of her claims. But the one that he did say with prejudice for, the very first one, is a federal statute. It used to be just for criminal, but it was converted and allowed to be used for civil as well. I find his ruling on this erroneous, and that's what we're going to talk about through the video. This one is dedicated to all the law nerds who just can't get enough of the behind-the-scenes sort of stuff to do with laws and with documents and the rules and the statutes and how it all works. So this one took me a very long time to put together just because I love that stuff. And in the end, when I first recorded it, it was like 2 hours long. And so I cut some of the stuff out because I know I get carried away with it, but not everybody does. Some people just want to hear the nitty-gritty details of the case. So I did cut a lot of it back, but I left enough in there to try to explain why things work the way they work, which is the kind of stuff that I love. Kimberly says, we wouldn't be here if we weren't law nerds. Awesome. Awesome. So that's what we're going to get into today because I feel that he made a huge mistake with this, a huge mistake. And when you say that a judge made a huge mistake, I feel like you have to back it up. So that's what I tried to do with this episode, to gather as much proof and as much case law and as much background information to try to back up what my claims are. And I thank you so much, Joel of Creative Tennis. Did you buy a CD player yet? I did not. I don't have a CD player, a DVD player, nothing. I think somewhere in storage I might have like a portable CD, DVD, like you put it into your computer if you don't have one built in. And that way you can still play or record things onto a CD or DVD. I think I have that somewhere in storage, but I haven't, like my PC doesn't have a slot for one. I use my tablet as a Surface. That doesn't have one. I use that like instead of a laptop because it's smaller. But yeah, I don't have. I know some people were saying you can use like an Xbox or one of those game players. I don't have one of those either. So, but I think whoever gets it first is gonna put it out there, and after that, I think the rest of us don't really need to go through the trouble of buying one. So I know there's Inner City Press on X. And then someone sent me a screenshot of who this Clark person is on Reddit. So I don't have Reddit, but I think once it hits Reddit, I think other people will grab it and share it. So I don't think it's something we have to worry too much about all going out and buying it, because if we're not local, we have to send in our information, send in our payment, and wait for it to come by snail mail. We are really living in the 90s, people, with this situation. It's really, really crazy. So I think local people are going to go down and get it, and they're going to share it. And I think we'll all have it tomorrow. That is, well, did you guys see that the judge ordered she has to have it to the courthouse by tomorrow? So, Tina says she's an antique dealer. She's got the ancient devices. Oh my goodness, that's hilarious. Yeah, Christina says someone will digitize it for sure. I agree. People can't wait for the Gwen still has an old 8-track player. My parents had one. They had this big stereo, like an antique. And I mean, this thing was huge. It was the size of like a buffet. And is that what those things are called? A buffet? Where you can put dishes inside and then you could put stuff on the top. It's like where you put your good stuff for like your big family dinners, your bigger pieces of things that you don't use all the time. But it was like that shape and style, and it must have been fancy in its day. It had a record player, and then it had a cassette player, and it had an 8-track, and it had a radio. Yeah, like a china cabinet, a buffet. Yeah. I think it's called a buffet when it's just the lower. But yeah, it was so funny. And I haven't seen one of those in a console. Is that what it's called? Yeah, it was huge, and we loved it. We used to get in trouble for sitting on the corner of it and listening to it. But yeah, because you just like wanted to change the channel all the time if you were listening to the radio or if you were trying to play an old record or something. I love old music, and they had some old records. We love to listen to those. Yes, it was a huge piece of furniture. But they haven't had that thing in ages. So yeah, but that had an 8-track in it. So I've seen those before. But how fun. How absolutely fun to drag out all these things just to I was laughing that Goodwill's gonna sell out of all their CD players after this. But so back to this story. So I'm gonna go ahead and start this video because it's a little bit long. I think it's just about 50 minutes. But it kind of requires that because, like I said, I'm making a bold claim in here that this federal judge made a mistake in his ruling. And so I wanted to back it all up with as much proof and evidence as I could. So let's get started. If you know anything about the Wild West, you know that it was very uncivilized. If you know anything about the Wild West, you know that it was very uncivilized. People were slowly expanding the territory from the original colonies on the East Coast and pioneering their way across the country. They were in search of things like gold. So it wasn't every piece of society that moved. It was prospectors first, that later moved their families with them. That meant there weren't stable laws. There was the Code of the West. It was unwritten. It was unenforceable. Outlaws went west sometimes to flee. Because law enforcement was so minimal, or even in some places non-existent, vigilante law became a thing. There was no due process. There were no trials judged by your peers. It was, in fact, wild. Even as law enforcement did start to appear, with marshals and sheriffs and constables, they didn't have much oversight, And as always, they could be bought. And they were bought by things like railroad companies, who paid to be able to put their tracks down through the land to have easier access to gold and other things that were being mined. I feel like we're experiencing these very things now. We have people who are supposed to be upholding law, who are supposed to care about justice, and we've seen them do unspeakable things. We've seen Van Zandt, an absolute sham of a lawsuit, to come up with an absolute sham of a subpoena to serve on a young woman's phone without her knowledge, without the opportunity for her to fight back, just stolen from her by wealthy, powerful people. The information obtained by this sham is sitting in a New York federal court docket as we speak, being used against her and everyone she communicated with. If that's not the Wild West, I don't know what is. How was this able to happen? Money. Money and power. Just like the Wild West with the railroad companies. They could take people's land, put their tracks down right through it, mess up their livelihood, and nothing could stop it, because the law served the wealthy instead of the citizens. Judge Liman ruled on a motion to dismiss earlier this month. He spent 9 pages telling the story of the taking of Jennifer Abel's phone information, wrote out the entire story, knowing that all of this happened in a New York court, knowing the rules of how wrong this is, and still saw fit to dismiss almost her entire case. This time, he dismissed all but one without prejudice, so she has a chance to try to cure the defects and come back. Do I have any faith that he might change his mind? Absolutely not. I'm going to go through each and every cause of action that he dismissed. The first one is the one that he dismissed with prejudice. And it's the most shocking to me, because he took away her right to even try to cure this. But the most shocking bit of all is what he did in order to make that decision. Brace yourselves. I often say that nothing about this case shocks me, but this shocked me. Some of these concepts that we're going to talk about today, I've talked about before, so if you followed me for a while, you already know these, but we're going to review them. And it's really, really important to understand them to fully be able to grasp exactly what Judge Liman did in order to grant the dismissal of these causes of action. So settle in and pay attention, because in the Wild West, you had to be on alert all the time. There were dangerous animals everywhere. Now, as I said, he spent the first 9 pages going through the history of the case from Jennifer Abel's standpoint, and I couldn't help but wonder what was going through his mind as he wrote this. If there is truly any love of justice in his blood, even one drop, this should have angered him. If it didn't, something is very wrong. I also wondered as I read it if it made Manat's blood run colder than it usually runs, seeing their actions written out by a federal judge. I hope he felt hotly ashamed of himself when he was writing the bit about Edgeworth's security, thinking back to the time that he ruled in Jonesworks' favor, protecting Edgeworth's security from having to disclose what they did to Jennifer Abel on that fateful day. Not only did he just rule in their favor, but he refused to even do an in-camera review. I reported on that at the time, but it still drives me crazy that he wouldn't even consider taking a look at the information to see if it met the standard. He absolutely refused. Then, when it came to Jennifer Abel's text between herself and her father, he was all in. When faced with reviewing a possible crime that was committed, no, he wouldn't be bothered. But when he saw a girl in a legal mess speaking to her father, who's an attorney, he was all in. Jumped straight into an in-camera review. It boggles the mind, some of these decisions that he's made. I mean, we have a girl in a legal mess talking to her attorney father on one hand, and on the other, we have a security company that blocks a young woman in a room demands her phone, scans her personal property, her laptop, and when they find nothing, they can't accept it and do it again. They refuse to return her phone and then scrape every last kilobyte of information out of it. They share it by means of a scam lawsuit with a scam subpoena, and he's like, no, I don't need to look at that. But by all means, bring me these messages between her and her father about the family dog. That is a must read. That's what you want an in-camera review on, not a sham crime? This decision to do an in-camera review on Jennifer Abel's messages and not do one on a potential criminal lawsuit is a blunder that will be studied in law school for decades. It will have professors and students scratching their head to try to understand it. Because when you're studying law, you have big dreams that you're going to make a difference in the world, that the law is there to protect the little guy, to balance things out, that justice is blind and justice is fair. And then you see this kind of stuff, how it's actually exercised. And you realize that it's all just a big fairy tale that we tell ourselves to feel better about society. That if something goes wrong, if someone mistreats you, if someone harms you, you have somewhere to run to receive justice. But it's a fairy tale because laws are written to make harm to people illegal, to deter crime, to restore things. But after the laws get painstakingly written and enforced, they get brought to court. And what happens in court? Everything possible to destroy the law. So people harm. The law says you can't do that. And then you go to court and the court says, well, is it really a crime? Is what they did really so bad? And people either get away with it or get minimal punishment. That's what happens in court. Very few people are ever held responsible for what they've done. And that's the sad truth, whether it be criminal or civil. And this case, I think, has made us by and large absolutely lose faith in the justice system, at least the one in the Southern District of New York. It's made us lose faith in media because we have witnessed that money and power can buy both with our own eyes. The things that are happening in this case are atrocious, and the court's allowing it, and the media is not reporting on it. Someone commented on my live the other night, and it really stuck with me, that this judge's decisions don't just affect this case. They become part of recorded decisions that other judges can use to make their decisions. This is not a small thing. Every time an erroneous decision is put on the record, another judge can come along and take that decision and apply it to their decision and continue the error. So this isn't just about all the bumbling ways that he's handling this. It's about future cases in the Second Circuit, which is a big circuit, and it's a circuit that feels very important about itself. It's New York. We've talked about this standard many times already, but for any who are new here or who haven't heard of it, there's a legal standard that's looked to in deciding judgments on pleadings and motions to dismiss. To keep it simple, it's a standard judges are supposed to use to make these decisions that's supposed to keep things fair and equal across the board. These types of motions can only consider what's referred to as the four corners of the complaint, meaning they can't take anything else into consideration beyond what they're given in the motions. That's why it's so important to include everything, every possible argument you can use. And you'll see attorneys argue based on one thing, but then they'll say, if not that, then this. And then they put up a whole new argument. You can say throwing spaghetti at the wall to see what sticks, and it may seem funny to us when we read it, like they don't think their argument is strong, so they're trying everything, like they're desperate. But the thing is, if you don't do that, you tie the judge's hands. Maybe he or she agrees with your case, but not your argument. But if you only provide one argument, they can't rule in your favor even if they agree with you because you haven't given them something that they can use to make the ruling. So when you write these motions, it's really important that you give everything you've got. You've got to meet these standards, and you've got to give the judge options. So this standard, referred to as Iqbal-Twombly, comes from two separate cases. Twombly was decided in the U.S. Supreme Court in 2007, and Iqbal also in the U.S. Supreme Court in 2009. Together, they describe the standard of what it takes to survive motions to dismiss. it comes to plausibility. Your motion has to plead factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. It calls for enough fact to raise a reasonable expectation that discovery will reveal evidence that supports the claim. So it's a decision that's made without the discovery, without the evidence, but your claims must be so reasonable and so well pled and filled with factual content that a judge can look at it and say, okay, it sounds plausible that they will be able to prove their case. We're going to talk a lot about the U.S. Supreme Court and binding authority. These two cases, for example, as I said, were heard by the Supreme Court. They are now what's called binding authority, and we're going to come back to it. But just like we're considering this today, this is a standard that has to be followed. So keep that in mind. There's a lot of things I'm going to ask you to remember as we develop this. The Computer Fraud and Abuse Act, also called the CFAA, was created in 1986. It has had multiple amendments and even more updates through the years because technology has grown tremendously since 1986. I mean, the internet didn't even exist yet then. So it's a law that has and probably will continue to change through time. It's a long code, huge, several pages. And if we look at his description of it, he makes a good show of quoting from it. As he states, the CFAA makes it illegal for an individual to intentionally access a computer without authorization or to exceed authorized access and thereby obtain information from any protected computer. It talks about how it began as a criminal statute and how it was later adapted to also cover civil actions. He quotes the part of the law about what it takes to be able to bring a civil claim of this law, and he mentions that the scope of civil actions has been limited, and that's true. And he quotes from Hancock, which came out of the Second Circuit Court of Appeals. We're going to talk about that case for a minute, but let's look at the footnote because that's important. He says there is no dispute in this case that the phone qualifies as a protected computer under the CFAA. So that's not in dispute. Jennifer Abel's phone meets the standard. It is considered a protected computer. So she's halfway there. But let's look at this case that he quotes from. So this is a case that came under two claims. There was a privacy violation alleged and a violation of Section 1030. It was brought about because a coworker had accessed some of its fellow employees' medical records, something they did not have authorization to do. Now, the Northern District of New York dismissed all of the claims because they failed to allege any impairment or economic loss and then granted summary judgment against the privacy counts, saying that if medical conditions are non-discriminatory, if it's not something that causes you to be discriminated against, that it doesn't trigger a protected privacy interest. And it went, as we know, to the Court of Appeals. They affirmed the dismissal because there were no damages found, but they reversed the summary judgment saying it doesn't matter if this medical condition is discriminated against or not. It's still medical information, and so it's still a violation of your privacy. So the binding authority, and we're going to talk a lot about that in just a moment, as I said, is that you have to be able to show damages in order to make a 1030 claim. Now I want you to pay attention to the wording of this. This is directly from 1030. We'll look at that in a moment. But what the law itself requires is that you show at least $5,000 in economic loss within 1 year or actual impairment to the integrity or availability of a protected computer. In this particular case, plaintiffs were not able to show any damages or any proof of economic harm, and so that's why their claim couldn't proceed. This is actually written into the law, and now it's binding authority because it was decided by the Court of Appeals. What does that mean? Binding authority refers to legal sources that a court is obligated to follow when deciding cases. These sources include things like constitutions, federal and state statutes, judicial opinions from higher courts within the same jurisdiction. That last part is what we're going to focus on, and I've mapped it out to help understand better. As you know, there are two very distinct branches to the judicial system. There's a federal branch and there's a state branch. Every state has their own constitution and their own statutes. So state courts function just on the concepts of their own states, but they all must be under the U.S. Constitution. Now, the federal branch also operates under the U.S. Constitution, and the U.S. Supreme Court interprets the U.S. Constitution and federal statutes, whereas state Supreme Courts interpret their own state's constitution and statutes, but they must be in harmony with the U.S. Constitution. So on the federal side, these federal statutes are enacted by Congress. On the state side, they're enacted by state Senate and state House. Now, the U.S. Supreme Court is the highest level court, but surprisingly, it has little to say over the states. So a state Supreme Court is the highest you can go in that state if there's a question of federal law. That can be appealed to the U.S. Supreme Court, but only that aspect of a case. And that's kind of few and far between. When federal judges make erroneous rulings, it gets appealed to the U.S. Court of Appeals. So when you hear us say Second Circuit, but that is their appellate court, and these cover multiple states. I've shown maps of the different circuits before, but we're specifically speaking of the Second Circuit. That is the U.S. Court of Appeals that's above Judge Liman. Now, the note next to the U.S. Court of Appeals, it's binding in its circuit. That means that when you have a ruling by the U.S. Court of Appeals about a specific subject, every federal district court in that entire circuit must rule according to the Second Circuit Court of Appeals decision. Must. Whether they agree with it or not. It's binding, and they must. And if they don't, it's easily overturned. Sometimes, and we've discussed cases like this before, it goes through the Court of Appeals, they make a decision, and that decision gets forwarded to the U.S. Supreme Court. Now, it's rare, the acceptance rate is very small, but if a case goes to the Supreme Court, that Supreme Court decision is king. There's no higher court. There's nothing you can do to change the U.S. Supreme Court's decision. That's something that only the U.S. Supreme Court can overturn. So the U.S. Court of Appeals is bound by decisions that have been made by the U.S. Supreme Court. They become law. That means everything Judge Liman decides, the first thing he should do is check the binding authority. Has the Supreme Court already ruled on this? Has the U.S. Court of Appeals of the Second Circuit already ruled on this? If either of them have, he must follow their decision. He has no choice. This concept is really, really important to what we're talking about today. So when federal district court judges are deciding the big things, such as dispositive motions, motions to dismiss, motions for judgment on the pleadings, motions for summary judgment, a couple of things we haven't gotten to yet, but motions for a directed verdict or a judgment notwithstanding the verdict, these are all big decisions. They always have to look at the binding authority first. So back to this case that he quoted from, this Hancock, that's what he did. He chose a case that was decided in the Court of Appeals in his circuit. You see the 2D CIR at the top? That lets us know that this was a decision by the Second Circuit Court of Appeals that happened in 2018. Now, he chose to focus on there must be $5,000 worth of damages shown. There must be economic loss shown. We understand that. That's in the law itself. That didn't even need interpretation. It's actually in the statute. However, I have a huge problem with his decision. Let me explain. And it's why we just went through that chart. This chart that I spent a good hour making. This case he cited was a good choice. It's binding authority, like I said, because it's from the Second Circuit, his circuit. And what do we learn from that chart? We're going to review it because I really want you to have this in mind. The Court of Appeals is above the federal district courts, right? Liman's Court, the orange box, at the very bottom. I know I just said all this, but I'm repeating it again. He is bound by the decisions made by everything above him. You see the three things that are above him? There's the U.S. Court of Appeals, there's the U.S. Supreme Court, and then we have the statutes themselves. He's the bottom. Now, are you ready to get mad with me? Just look at this. After he says, Jones says that Abel didn't adequately allege damages, and Abel says, but I did. I included loss of privacy and reputational interest and control over personal data, the expenditure of funds to regain control over accounts, and legal expenses arising directly from the CFAA violation that exceeded $5,000. She's like, I did show you these losses. These are my losses. What does he say in green? These allegations are deficient. That's what he says. Keep this in mind. Then he says, damage is defined in the statute as any impairment to the integrity or availability of data, a program, a system, or information. And loss means any reasonable cost to any victim. The law says that, right? But let's talk about what he does next. Now, part of his objection at the very bottom is he says that the claim is conclusory. That's not a bad objection, because what that means is show your work, basically. Do you remember when you were in school and you were doing math and the teacher said, you have to show your work? She wanted to make sure, first of all, that you weren't cheating and using a calculator or copying somebody else's answer. But also, she wanted to see not just the answer, but how you got to the answer. Conclusory means you didn't show your work. You got to the conclusion without explaining how you got there. Now, these kinds of objections are usually curable. You just take your paper back, you show your work, and you hand it in again. But this particular claim was dismissed with prejudice. So this option has been ripped from Jennifer Abel's hands, just like Stephanie ripped the phone from her hands. Now let's go back to the mad stuff. Why am I so mad? I'm mad about his other objections. Let's talk about definitions. This is a very long, very detailed, very well-written law. It shouldn't have to be dissected so harshly. It shouldn't have to be twisted till it's no longer recognizable. It's already long. It's been amended. It's been updated. It's full of details. It's not one of those laws like 47.1 that's very basic, doesn't have enough information to even know how to use it, how to apply it. It's not like that. It spells things out very, very clearly. Let's go straight to the point he's talking about. He says section 1030E8. It says the term damage means any impairment to the integrity, this is the key, or availability. Now he has turned a blind eye to this word, and this is his error. He acts like this word doesn't exist, but it does. Of data, a program, a system, or information. This is hugely important. And then he interprets loss as any reasonable cost to any victim. That's wide open, right? And then he goes on to quote section 1030E11. Let's read it straight from the law. It says, the term loss means any reasonable cost to any victim, including the cost of responding to an offense, conducting a damage assessment, and what? Restoring the data, program, system, or information, that's another important word, to its condition prior to the offense, and any revenue lost, cost incurred, or other consequential damages incurred because of what? Interruption of service. This law couldn't be easier to understand, especially as laws go. But we understand you're talking about a device. And as he said, there's no question that this phone, because this was written in 1986, it refers to computer. We didn't have smartphones then. Not many people even had computers in their home then. And so it's come to apply to things like phones and tablets. So her phone being considered a protected computer is no question. That's not up for debate. That's already sorted. So when you're talking about bringing something to the condition prior to the offense, revenue lost, costs incurred, consequential damages, because of what? Interruption of service. That's what we're going to dive into. Remember these words: availability, restore, revenue lost, interruption of service, information. All of these words came directly from this statute. Write them down if you have to. We're going to talk about these again and again. This is the law code, right? Where does it fall on this chart? It's not directly under the Constitution because the Supreme Court has rights to strike it. But right there it is, beneath the U.S. Supreme Court. See the fuchsia arrow? It's between the Supreme Court and the Court of Appeals. And where's Judge Liman? He's orange at the bottom. Then he quotes from a U.S. Supreme Court case. As he should. We know where it's at in the chart. It's beneath the Constitution. Highest court in the land, right? The case he quotes is Van Buren versus the United States. This was decided in 2021. Now the focus on this case is correct. He's supposed to check binding authority when he makes his decisions, right? And this case makes important distinctions about someone who may have authorized access to a computer, such as having a passcode. They have every right to access the computer. However, there are limits to this. So in this case, a police officer who has the right to look up registrations, they have the authorization, but if they use that access in a manner that exceeds their authorization, they are still violating Section 1030. So Stephanie Jones and her supporters have tried to claim that she owned the company, it was a company device, and so she had authorized access to it. This case says that's not always true. There were bits to Jennifer Abel's phone that even though it was company-owned, she still had no legal right to access. That's the whole point of this case that was decided by the U.S. Supreme Court. Now, he's trying to make it seem like he's doing the right thing by making a decision based on a U.S. Supreme Court case, as he should. Let's read this opinion. The provision under which Van Buren was charged also gives rise to civil liability. See Section 1030G. Remember, it started out as criminal, but it was adapted to include civil. The provisions defining damage and loss specify what a plaintiff in a civil suit can recover. Damage, the statute provides, means any impairment to the integrity or, and they're quoting from the law that we already read, so we know this word exists, availability of data, a program, a system, or information. The term loss likewise relates to costs caused by harm to computer data, programs, systems, or information services. So these definitions focus on technological harms, such as the corruption of files, of the type unauthorized users cause to computer systems and data. Now remember, this law was written to apply to hackers who would get in and destroy things in people's computers. But in the law, it specifically mentions availability, and when it talks about technological harms like the corruption of files, it also mentions the word data. Data is not a piece of a computer. Data is stored on a computer, but the concept of it is not physical harm to a computer. It's about the information that's on the computer. So why am I angry? We have a Supreme Court case here that quotes the law and sets binding authority, repeating what the law says, that damage can and does mean the loss or impairment of availability, and specifically refers to data. Didn't Jennifer Abel's claims clearly say, and on page 38 of this very document written by Judge Liman, it says, Abel alleges that her inability to access her phone number cut off her access to critical accounts protected by two-factor authentication, and that it took over a month to regain control over all of her accounts. Add this to the list of things we're remembering, okay? We're remembering availability, interruption of service, data. Now we're adding this, cut off her access, took over a month to regain control. Do you see where this is heading? So here's what we have so far. We have the power chart showing that the U.S. Supreme Court at the tippy top of the federal branch. Immediately under, we have the federal statutes. And then, of course, the Court of Appeals, and then Judge Lyman's Federal District Court. Here on the right, we have a Supreme Court decision, the one we just looked at. And what did it say? It said that damage is any impairment to the integrity or what? Availability of data, a program, a system, or information. Look at the bottom left. This is Judge Lyman's own words written, where he knows that Jennifer Abel said she lost the ability to access her phone. What is that? Availability of data, right? He says they cut off her access to critical accounts. It took over a month for her to regain control of her accounts. What does this Supreme Court decision say? Availability of data, a program, which in modern days is an app, right? A system or information. Was there harm to her data? Yes. She had no access to it. She had no access to information that was on her phone. These things were unavailable to her because of Stephanie Jones' actions, just like is decided by the Supreme Court 4 years ago. So we can check Supreme Court. What else? We have these two federal statutes. E8 says damage means any impairment to the integrity or availability. Right there. E11, the cost of responding to an offense. How many ways has Jennifer Abel had to respond to this offense? Restoring the data. Isn't that what she said she had to do? Program, system, or Information. Information is not a physical, tangible object. To its condition prior to the offense, that's exactly what she had to do. She had control. Stephanie Jones took it. She didn't have control. So prior to the offense, she had it, and she didn't have it. She had to do something to get it back. And any revenue lost, she was starting up a business. Now all of a sudden she didn't have access to the apps that she needed. Everything called into question about her by Stephanie Jones, out of nothing but spite. She had clients who adored her. We know that. Clients who wanted to follow her. And what happened because of Stephanie Jones's actions? I'll tell you this, it's going to be a lot easier for Jennifer Abel to prove lost revenue than it will be for Blake. Cost incurred or other consequential damages incurred because of interruption of service. You think being locked out of your phone for over a month, not being able to do this two-factor authentication? Because we all know you can move your data to a phone and it's all there, but you lose all the sign-in to your apps. You have to sign in. And what do they all entail? Two-factor authentication. She's telling the judge, I couldn't do it because she had my stuff. And he's saying, no, this is deficient. Well, the Supreme Court didn't think so. The federal statutes don't think so. Only you think so. Let's move on. It gets worse because he ignores all of this. He took a little bitty piece out of this Supreme Court case. It looks like he didn't even read it. If he didn't bother to read it, then he didn't even know what the case was trying to say. And if he did bother to read it, that's even worse. Because look what he says. He says, basically, forget about this U.S. Supreme Court binding authority, because here in the Southern District of New York, where we think we're our own planet, both before and after the Supreme Court's decision in Van Buren, courts in this district, sorry, sir, you're still in the United States, have interpreted the CFAA to require loss related to damage or impairment of the target computer itself. And then he quotes two cases. From where? From the bottom of the totem pole, the Southern District of New York District Court. He's like, we're not affected by the Supreme Court binding authority. We interpreted before that and after that in our own way. When we decided that it's loss or damage to the targeted computer itself. Is that what the law said? Is that what the Supreme Court said? No. But he's like, screw these things that are above my head that I'm bound to follow. We, in the Southern District of New York, do what we want. And we say it's this. The gall of this man. This is why he supports Blake. Because he's just like her. In my opinion, don't subpoena me, Lewis. Just like Blake, who admitted in an interview that she goes to a job interview and pretends she's gonna just be the actor, and then pulls the rug out from under their feet when she starts trying to take control. Her own words told us that. Not just her actions that we saw. Her own words admitted it. Now we have Liman, who swore an oath that he would follow the laws of the land, that he would rule fairly, that he's bound by the Constitution, that he's bound by the U.S. Supreme Court, that he's bound by the legislature, that he is bound by the decisions of the appellate court, and then gets his position and says, I don't want to do that. We do it our own way here. I'm in control. I make the call. I'm the director. Where's my PGA credit? Are you as angry as I am? And then he dares to say, Abel's only relevant allegation as to damages is what she expended funds to regain control over her accounts. That's all. And even in this sentence, he's admitting that these things were not available to her, that she didn't have control over her accounts, ignoring the fact that that right there, that sentence right there that he just wrote, falls under what this law is. But he minimizes it. Only it's conclusory and merely parrots the statutory language of the CFAA. Did she just parrot? And you know, it's funny because I've used parrot so many times to represent Michael Gottlieb because he just keeps saying the same thing over and over again. Parroting something. What an insulting thing to say. When you parrot something, it comes from the idea of people who've taught their parrots how to speak. A lot of times they don't even know what they're saying. They're just repeating something that their person has repeated to them over and over and over again. So he's saying she doesn't know what she's talking about. She's just repeating this. How rude is that? He's the one that doesn't know what he's talking about, which would be the lesser of two evils, because the worst would be is that he does know and he still makes this ruling anyway. So again, just to review, here's what we've got so far. We have the Supreme Court decision and we have the statutes. There's one spot still higher than Liman's court on here, and that's the Court of Appeals. Did he snub them as well as the two highest? Let's look, because I found this case. This was just argued 2 years ago. It was a case decided by one of his colleagues, Woods, in his own district, the Southern District of New York. It was brought to the appellate court. This happened during his time as being a judge. I imagine judges are probably aware of what's being appealed in their circuit. They don't like to have their judgments appealed. So no doubt when it happens, they take note. He should be aware of this. Now, the reason for this appeal in particular was venue. However, in the course of it, the actions are affirmed as well. So the reason that venue was being argued is that this was a multi-state company. Some of it happened in Florida, and some of it happened in New York. The defendant was a Florida-based human resources manager who sounds a lot like Stephanie Jones. It was an accounting business, and they had contracted with the software vendor Jazz HR to create an applicant tracking system database. Now, Kalange had super administrator access because she was an HR manager. Amy Gaspari was her supervisor. Gaspari was based at the headquarters that are in Manhattan, which is why this takes place in the Southern District of New York. Kalange was struggling, and like I said, sounds like how they say Stephanie Jones is. And in June of 2019, she had improperly locked another employee out of another human resources software program, and it prevented him from performing his job. It doesn't say clearly, but it sounds like it must have been intentional, because after she did that, they decided to terminate her. And you would think if it had been accidental, that could have been smoothed over without terminating her. Now, after the termination, most of her credentials were revoked, as they should be. But Gaspari, for some reason, neglected to revoke her access to the Jazz HR database. What did she do? Well, that weekend, an employee informed Gaspari that he was unable to access this database. The following Monday, another one was unable to. Eventually, Gaspari was able to successfully log into the database and found what? Nearly all the information on it had been deleted. Sounds like the same spiteful, childish nonsense. And so what happens? They have to hire someone to help them recover the data. It's very expensive. It takes 6 to 8 weeks to reconstruct it. It was a nightmare. Now, the important point here is nothing was physically wrong with those computers. The computers were in Manhattan, untouched. The defendant had accessed it from Florida and messed with only what? The data. Now, remember, Judge Liman says here in the Southern District of New York, we say what? Damage or impairment of the target computer itself. That's what he rules. That's the theory that he based his decision on. What does the Court of Appeals say? A lot of this argument is about the venue. We're not going to touch that because that's not important. But like I said, in the process, the actual criminal actions are affirmed. The jury was instructed that damage under CFAA covers any impairment to the integrity or availability of data, a program, a system, or information. That's a quote directly from the law. You know that because we read it together. This is what the Court of Appeals determined. This damage includes availability of data, program, system, or information, which would include an app. Because an app is basically a program. They continue. Each relevant subsection of the CFAA contains at least 2 essential conduct elements. The first, and they read from 1030A 5A, which says it bars 1, knowingly causing the transmission of a program, 2, intentionally causing damage. The second subsection bars intentionally accessing, and 2, recklessly causing damage. And then it talks a little bit about the venue again, but let's get to the important part. Constitutionally sound venue existed in this case so long as the government established by a preponderance of the evidence that Gaspari's computer in the Southern District of New York was damaged by Kalange's conduct. In other words, that Kalange caused an impairment to the availability of data. Gaspari testified that when she logged in, she no longer had access to the data. Just like Jennifer Abel tried to sign into her apps, but she couldn't because she no longer had access to her data. It's the same thing. What else? They rule. Kalanji argues that deleting data from the Jazz HR database did not damage any protected computer. This is just like what Judge Liman is trying to say. It's tangible damage to the actual computer itself. What did the Court of Appeals say to that? The text of the CFAA is clear that preventing a computer from accessing data that it regularly accesses constitutes damage under the statute. Jennifer Abel not being able to access the data constitutes damage under the statute. The statute defines damage as any impairment to the integrity or availability of data, a program, a system, or information. That's how they interpreted this law. That's easy to interpret even without this. The jury was entitled to conclude that Kalanji's actions impaired the availability of data on the Jazz HR system on Gaspari's computer. And then, like Jennifer Abel, they were eventually able to restore it, but it's still damaged because for a time they did not have access. And that's what this law covers. How did he miss this case? He is supposed to look first to binding authority. But he said, no, I know better. I'm in the Southern District of New York. Here's what we do here. These are not old. These are current. These happened since he's been a judge. Now here's what we have. Not only does she have the privacy rights of the U.S. Constitution, she has a Supreme Court decision, 2021. They clearly defined availability of data is included in the definition of damage. And loss defines harm to computer data, not the physical computer. Data, programs, systems, information services. What does that entail? All of the things that Jennifer Abel was locked out of because of Stephanie Jones' actions. By Judge Lyman's admission in this paper he wrote she was cut off from for over a month. Then we have the federal statutes. We almost know them by heart now. We've read them so many times. Any impairment to the availability of these things, the interruption of service. Now we have this decision by the Second Circuit Court of Appeals from 2023, 2 years ago, a year before this case began. And he didn't even consider it. It's not even on this paper. I found it. I'm not a judge. Why didn't he find it? He's bound by it. And they said the text of the CFAA is clear that preventing a computer from accessing data that it regularly accesses constitutes damage under the statute. The statute defines damage as any impairment to the integrity or the availability of data, a program, a system, or information. Her actions impaired the availability of data on the Jazz HR system on Gaspari's computer. Identical crime, really, for all intents and purposes. So looking at this chart I made again, Constitution, her privacy invaded, check. U.S. Supreme Court, check. Federal statutes, check. U.S. Court of Appeals, check. He's at the bottom. What did he use as his authority? None of the things he is bound by. He said, well, here in the Southern District of New York, this is what we do. And quotes 2 cases from this bottom-level court as the authority to make his decision and dismissed it with prejudice. What is wrong with you, Lewis? Your Honor. That's what he said. Both before and after Supreme Court's decision, the courts in this district have interpreted the CFAA to require loss related to damage or impairment of the target computer itself. See these 2? This is what we do here. And quotes these lower court decisions. This is doing it backwards. And the only reason that you choose to do it backwards like this is that you already have your mind made up of what you want to do, and you try to justify it. But in this case, he is not allowed to do that. He is bound by the higher courts and the statutes and the Constitution. Shame on you, Lewis. Really, just shame on you. This is disgusting. I am so outraged. When you swear an oath to uphold the law, this is not what you do. And people want to defend this man. Why? People read this. How many attorneys read this? And just said, oh, okay. He dismissed it with prejudice, blah, 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 blah. Why didn't anybody look into this? Why didn't anybody question it? And want to scold us for saying something's wrong here. Want to scold us for saying he's making bad decisions. Want to scold us for saying he's biased. How do you explain this? If it were you, if you were Jennifer Abel, wouldn't you be questioning these things? Wouldn't you hope that somebody somewhere is questioning these things? Would you just say, well, he's a judge. It just doesn't sound fair to you guys because you don't know better. I'll tell you this. I'm smart enough to know how things work. I'm smart enough to understand case law and power and binding authority. But besides of all that, I have the desire to get to the bottom of things. I have the desire to see true justice served. And that is a driving force. And Jennifer, I don't know if you watch. Probably not. But I hope you know that there are thousands of us, tens of thousands of us, who know this is wrong. You are not done right, and we want to see justice for you. Please take this information and do something about this. This is error. Absolute error. Applying district law is a huge error. She could replead to damages. Her allegations absolutely do say how she was impaired. He's wrong about that. She was locked out of critical apps because she couldn't authenticate. She was just starting her own business. How does he think it went for her without access to the very things she needed in order to do that effectively? The statute is clear. The Supreme Court is clear. The Court of Appeals is clear. Everyone is clear except for the Southern District of New York. Being locked out or not having access and availability is the exact damages that this law was meant to protect. This is error, and it needs fixed. How can she fix it? She can appeal it under the grounds of error of law. He misapplied and misinterpreted the Supreme Court case, and it's binding. He took a little bit out of it. Isn't even what the thing is about. Misapplied, misinterpreted. Left out the bit where it quotes the rest of the statute that includes availability of data. He ignored controlling authority. He relied on district-level opinions instead of circuit or Supreme Court precedent, and in this case, there were both. He misread the statute itself and failed to properly apply it. In his own words, it said availability of data, and he just went right over it. He mistakenly defined damage to mean to the physical computer itself. That's not what the statute says. That's not what the Court of Appeals says. That's not what the Supreme Court says. He mistakenly defined loss. If she appeals it and the appellate court agrees, it can reverse the dismissal or vacate and remand for reconsideration under the correct legal framework. This is error. And it's profound. This is not a simple oversight or a little mistake. It can either be one, he's unqualified to sit where he sits because he missed all of this, or two, it was done deliberately. Which one is it, Lewis? This is Cassidy O'Connell saying stay well, stay tuned, and stay honest. Hey guys. Alrighty, let me look at this real quick. Yeah, I don't know what they'll do. So someone was talking in the chat about the computer. If that were the argument that Liman made, I would agree with you, but he never once even hinted that that was his stance. That's not what he said at all. He said there was no question about the phone, and he said that this statute is actual damage to the computer and not about data. So this argument is only, just like he only addresses arguments that are addressed to the court, that's what I've done here. I've torn apart the argument that he put on this paper, and he never said anything about that. His argument, as you saw, was just specifically saying that it's about the physical computer. And then I found this other case in the Second Circuit. Now, this was a summary order, which is a little bit different. But it also says the plain language of the statute treats lost revenue as a different concept from incurred costs and permits recovery of the former only where connected to an interruption in service. And this one also clearly laid out that the losses could be recovery for investigation and restoration costs, which surely Jennifer Abel has, because we know in her paperwork, sorry, I'm struggling with my throat these days, um, that she discovered that Stephanie was still accessing her stuff up until January. So what does that tell us? It tells us that she had an investigation done. Someone forensically discovered how her phone number, which belonged to her, was still being accessed by Stephanie. And so we know this is why Stephanie kept her phone number, why she kept it for so long, so she could still keep this access. But again, I was addressing what Lyman put on the paper. These were his arguments. And he took arguments just from his own district level courts. He completely ignored the binding authority above him and completely ignored what the statute clearly says. I thought I'd put a picture in here of the entire law. I just showed a section of it, but it was the section that I showed had just 2 columns, but there was a whole nother screen that was 3 columns. This law is really, really long. It's very, very specific. And here's the thing, him making out that it's just about the actual physical computer. Sorry, I just moved the arm of my mic. It always screams when I do it. The physicality of the computer, this is long covered in law. It's not federal statute. It's state laws. It's one of the first laws written in the code. It's vandalism. It's destruction of property. When you're just talking about the physical computer, you don't go into these federal laws. Those are simple, basic laws, state laws about vandalism. This law was written specifically about hackers. Hackers are very, very rarely physically in touch with your computer. What they do is from a distance, through the internet, another way into your computer. So for the Southern District, he says the Southern District, and he put those 2 cases. He says, well, we see it differently, both before and after. So basically saying that this U.S. Supreme Court case decision had no effect on the way the Southern District of New York views this. But he said, well, we view it like this here, and says it's about the physical computer. That's just crazy. The physical computer would be covered by state laws of vandalism or destruction of property. This was written because of data and because of being cut off, just like we saw with the Court of Appeals case. This woman had, from another state, she'd gotten in there and wiped out data. The data is what belonged to this person. That person's computer was not harmed in any way at all. The only thing that was harmed was the data. The data was owned by that company because it was their data. This was Jennifer's data, owned by her, registered under her phone number, registered under her authentication. Yes, I agree. AF says, do not use the work phone for personal business ever. Exactly. It's not that expensive to keep your phone number on. I have a burner phone that I use for anything related to my social media. It's not registered to me in any way, shape, or form. The people that I pay through it for, they put it on there, and they don't even have my name. So, I mean, and it's not that expensive. You just get the cheapest, not Mint Mobile. yeah, I don't understand why. I mean, she learned the hard way, and when you're not a bad person, I think you don't think of ways that people could potentially hurt you. I'm sure when she signed up for that job, she was very hopeful and very trusting and very excited and didn't think about anything like this ever happening. But it's a really good lesson for all of us not to ever um, combine a personal phone with a work phone. Just just keep it. But in if you look at the Court of Appeals case, that was only data. It was software that was purchased by the company, and they kept her physical phone number. So and also, this isn't what Lyman argued. Lyman didn't say any of this. I'm addressing the arguments that he made to dismiss this case, and exclusively just like he did, the 4 corners of the document. The same thing. He didn't use this argument in what he said. I'm attacking his arguments. Him saying that the US Supreme Court ruled on this, but in the Southern District, we say this. I'm not going beyond what he put on his paper. And arguably, she kept her phone number, which is what all of this was under. He said, there's no question about the phone. He didn't use any of these arguments. So I'm not addressing anything outside of what he put on this paper, his reasoning for the decisions that he made. Because we could argue all kinds of things outside of the paper, but that's not what this is about. This is about his decision and what he used to support it. He didn't say anything like that. And if he did it, we would be having a completely different conversation here. But and I think the nuance of it is all like, what about her phone number? How does this all go about? Because like the Court of Appeals case, it was software basically that got hijacked. It wasn't a computer. The complete computer didn't get hijacked, just specifically one certain software. So yeah, I think as we as technology continues to change and grow, and there's different ways to access things, it's going to be hard for the law to keep up with all of that stuff and all the nuances of that stuff. So even this law, I mean, being written in 1986, a lot of things have changed since that time. And I mean, we didn't even have the internet then. And so these things have to constantly be updated, and it kind of leaves courts in the lurch because it takes so much time for laws to be updated and nuances to be embraced and understood. And then in the meantime, there's cases coming to court that the laws haven't been able to update what they how to interpret them, what they can mean. So it makes a lot of these things very, very difficult. Yeah, and those other statutes, those get addressed later. The Stored Information Act is the second cause of action, and so that will be the next one that I get to. But I'm going through each of them separately just from his rulings. So the Stored Information Act that you're talking about, that comes next, because he also dismissed that. And I think part of what he did is, sorry, I'm reading the chat too at the same time, so it messes up my line of thought. And I forgot what I was getting ready to say. Part of what he did, I don't remember what it was now. But, oh, part of the problem, I think, is that this is complex stuff. This gets into IT. And when attorneys are arguing stuff like this, what do? They get experts because they don't understand it. I don't understand it all. Of course, you go to school to learn this stuff. It's the kind of thing that does require an expert's testimony. An expert has to come in and forensically investigate all of this stuff. But then you have a judge that's ruling on the stuff, and he's not using experts to fully understand all of these things. And that's really scary. That thought to me, because that's what I was thinking about with this case. That thought to me was scary. Because if they're not getting expert opinion to make a ruling and they don't fully grasp the technology that they're ruling on, it's scary. How are they ruling on something that they don't understand? I mean, this courthouse is putting out CDs in order to get audio to the public. How far behind are they technologically? But they're making rulings without expert opinions to fully understand what they're even making a ruling on. So this argument by a virtual tourist is really, really interesting. But it's not one that he came up with. Why? Because he doesn't realize it. You know what I'm saying? So these things are just it's frightening. It's frightening that judges are making rulings without calling in experts to make sure that they're fully understanding what it all even means. Because this misapplication that he says is done in the Southern District of New York is not what the law says. It's not what it spells out. It specifically talks about being cut off from your data. And he's saying it's physical. That's vandalism. Pam, Pam says, "Oh my God, I will die if Reynolds is their IT expert." He does own stock in an expert, in an IT company now. Yes. Yes, Chris asks, "Can Stephanie get in trouble for accessing her accounts like her banks and email?" Yes, and here's the thing, this was just one. This doesn't cover all of the claims. There are, what were there, like 10? I can't remember the number. There were quite a few causes of action that she brought in her counterclaim. And so he ruled almost all of them dismissed. Quite a few he left without prejudice, which means that she can attempt to cure these. The thing is, even though he's giving her the chance to cure them, I don't have much faith that he will accept them the next time around. So it doesn't, just because he left it open doesn't mean that he's going to allow it later. So, but I don't know if you guys saw, Wayfair just hired 2 more attorneys. So it's exciting to me because I'm thinking they're amping up for what they're going to do next. And I really, really think that it's going to have a lot to do with the whole Van Zandt thing. I think they're going to come in hard. I think they're going to strike against the evidence, because how was it gotten? And we don't, in civil cases, we don't have what's called the fruit of the poisonous tree like we do in criminal cases. But if evidence is gathered in an illegal manner, even in civil cases, it can be struck. Brian Friedman said early on, when he first discovered this Van Zandt thing, he called it an abusive process. And it's not just a term, like, this is action that he can take against Blake Lively and against her team. This kind of thing can cause attorneys to be taken off of a case. It can cause entire law firms to be removed from a case. It's a big deal. If they bring that claim finally, along with something like summary judgment, or, at the same time as they bring the summary judgment, it could be huge for the case. So I think they're amping up to get ready to deal with that. There's also, if they lose the case, they're more limited. They're stuck with appeal. But if they win this case, either in summary judgment or through a jury verdict, either way, if they win this case, they can bring what's called malicious prosecution claim. They can say the way this was prosecuted was done maliciously. Look at where their evidence came from. Look at what they did to collect that evidence. Look at how many laws were broken to get this evidence. There's a lot of things that they can do. And so I'm thinking and I'm hoping that bringing on these new attorneys, and we just got a little bit of a glimpse with their motion for judgment on the pleadings, that they're going to do something. They're not just sitting there. People kept leaving taunting messages saying, oh, you thought Van Zandt was a big deal, and look, it was a nothing burger. They haven't done anything about it. But they hadn't deposed Van Zandt yet. Now they have. They hadn't collected all of the discovery yet. Now they have. Do you know what's happening right now? Right now they're deposing who? They're deposing the experts. This is all the steps that they had to do first before they can bring anything against Van Zandt. And so it's not that they just forgot about it, or that it was a nothing burger, or that the judge didn't do anything about it, because the judge can't rule on anything until it's brought to him. And up till now, it really hasn't been brought to him. So after all the discovery was collected, after their own experts did all of the forensic investigation that they needed to do to get to the bottom of this, after they deposed Van Zandt, after they deposed anyone else, we only know the people who were deposed that there was a fight about. Because if there's agreements on it, we never get to see it at this stage. They just quietly depose those people. We only get to see if there's some argument that they can't, not even an argument that they settle together, but an argument that they can't come to a conclusion on and has to be brought to the judge to decide. That's when we get to see it. So we don't know who all was deposed. And there weren't arguments really so much from Blake's side that would be about who was being deposed, who they were deposing for the Wayfarer side. So we don't know what happened behind the scenes. We only know what they fought about. So all of that information, and like I said, right now, they're deposing experts, and you better believe that any experts that they're consulting with and deposing might have something to do with this forensic investigation. So we don't know. We've heard very little about who Blake is deposing. So if Wayfarer has said, we're calling this expert and that expert that's going to look into all of this kind of stuff, and Blake said, okay, we're deposing them, and Wayfarer didn't fight, we would have no idea who these people are or what they looked into. So we have no idea what's been gathered. But it's still being gathered as we speak. And so nothing is going to be presented about Van Zandt until they have their entire case. Because bringing stuff to this judge, you have to have everything ready. If it's deficient, we know what he's going to do. He's going to dismiss it with prejudice. So they already learned by their motions to dismiss, by Blake's motions to dismiss their cases, how it works in this court. They're not going to come to him without the full story, without everything factually correct, without all of the evidence to support it. So hopefully we are finally going to see. And here's the thing, like I've said, and if Judge Liman has any bit of love of justice left in him, like one drop in his blood, he would be angry that this happened in a New York court. This has the potential to be really, really awful. If people go on misusing this, what they call a loophole, it's not a loophole. It's straight up wrong. It's straight up abuse of process. So if we've got him completely wrong, if there's something in him that's like wants justice, doesn't want to see the court system abused like this, he's going to do something about it. And that would be the first step, is making sure that something like this doesn't continue to happen in the New York courts, because I stand by, I don't think this was the first time this was ever done. I think this is probably something that's been done before, and that's how they knew to do it. That's just my thinking, because doing it for the first time on a case like this, that's kind of crazy. Of course, when they did it, there was no lawsuit yet, but there had to have been the intention of one, that Manat would be willing to do something like this. If that was going to be the only thing they did it for, that wouldn't be much money to go out on such a limb for. So I think they knew that a lawsuit was coming, and that's why they were willing to do it, because that was going to be big money for the firm. I don't know. I don't know what it would take to make someone who swore to uphold the law do something like this. Oh yeah, back to that question that I had put aside. So yes, if something is appealed and it's overturned in the appeal, it's basically nullified. So it's not used as precedent for future cases. It's never referred to again for a decision. It's basically nullified because it was appealed and overturned. So yeah, it will not affect future cases. If it's lost and appealed, it will be. Oh, absolutely. Absolutely. Because like I said, this I understand if he didn't want to rule on this right away. Nobody was telling the man, you got to rule on this by this date. So if he didn't want to rule on it at this time, okay, that's up to him. But he didn't have to give her 4 extra weeks to respond, because her request was already too much. The amount of time she asked for, I felt like was already too much. And then he's like, "Hey, not only can you have that, but I'm giving you even more, an extra 4 weeks to respond." That was ridiculous, because it's not like when she responds, it's not like the attorneys, all right, when one of them files this motion, the other side has maybe 14 days to respond, or in the big things, 28 days to respond. It's not like that for him. It doesn't matter when she turns that in. That doesn't have anything to do with the amount of time he has to respond. But he gave this to her, and it makes no sense. Yes, absolutely. Absolutely. I was trying to get some other people to go in with me as well, but absolutely. And I was hoping that at some point he is going to respond. Ken's put another one in, a more recent one. He still didn't respond to that. I wanted to take what the judge says and add that to the thing, because I'm hoping that if and when he finally addresses it, he will say something about the subpoena to show that the subpoena was improper, because that would hold more weight. But he hasn't. He's just completely ignored it. It's very, very disconcerting, and That's one of the things I really hold against him. Because and then he made that big deal in that last hearing. Well, does it affect third parties? You know what? Lewis, Your Honor, you didn't care about the 107 third party non-parties that were subpoenaed with the subpoena that wasn't legally sound. So why do you care now? Why didn't you care about us when our First Amendment right was being violated by a subpoena that was issued out of your court under your authority? All right, where? Sorry, this chat's moving kind of fast. Yeah, they were not, and he even said in the hearing, or was it on paper? I can't remember if it was the hearing or on paper. Um, so I don't want to get it wrong. It was one of the two that he would not rule this out based on the timing. And he couldn't because the precedent is already there. People have filed these even closer to the trial date and it's been accepted. So he didn't really have sound legal reasoning to rule on it timing wise. So he couldn't complain about the timing. And like I said, that whole, I don't know if you guys saw my last one, but I was talking about an attorney who was talking to us like we were stupid because we didn't understand the whole thing about law clerks. That's that's not even a consideration, frankly, because you can't say that people who have things before the court in September should that it's okay that they get less justice than the whole rest of the year because that timing's inconvenient for the court. If the court knows that September is going to be bad, then make an adjustment to your schedule accordingly. You don't get to penalize people who turn things in September because it happens to be busy for you. That doesn't cut it. That should have never been said. What a pathetic excuse. You should get the same justice every month out of the year. Okay, I feel like there was something, but it was kind of moving fast for a minute, so I missed a lot of. Yeah, I haven't had a chance to go back into that, but I heard that I heard about this, about the foundation and the charitable contributions, and there was also something about a connection between him and Sean Levy or Levy. Sorry, I always get names wrong. And even something that happened at his wife's college that his daughter attended. Is that none of I haven't verified any of this. So please don't say Cassidy said blah blah blah. I'm only saying what I heard. I'm not verifying any of this. I want to look into this. But what I read was that his wife and daughter attended the same college as Sean Levy or Levy's daughter, and they were at an event together. And it was some kind of fundraiser, and that Blake was the speaker at this. Again, I haven't verified this. This is what somebody else said, so I'm not saying this will happen. Please don't, if you repeat it, don't attribute it to me because I'm not saying this happened. I'm saying this is what I heard and I want to look into. I don't ever want to make that mistake again of repeating something that someone else said that I didn't look into yet, and then I'm the one that gets accredited or credited with saying it, and then it turns out to be wrong. So I think there's a lot more that needs to be uncovered. He gave her an extra 4 weeks to respond because they know we want to see a response. We have no idea how she's going to make her claims work after the MJP. Yeah, this is the thing. No matter how long you give this woman to change her response, What's she gonna do? Is she gonna move California to New York? An extra 4 weeks isn't gonna help that happen. It's not gonna make her claims all of a sudden valid. She would have to rewrite her entire thing and say something bad happened to her in California. Well, that's too late. Pam says Taylor dated a 17-year-old Kennedy boy, then bought a house nearby. His mother must hate Swift. Oh, yeah. Wasn't it one of Ethel's grandsons? I think so. That was interesting. I'll tell you what. I did you guys read the I put it on my community tab months ago when I listened to it. It was called Ask Not. I think no, not Ask Not. Oh gosh, I can't remember. But it went through, and we knew that JFK was a womanizer, and we knew about Chappaquiddick with Teddy. But I always was under the impression that Bobby was like this really good guy. But it went through so many Kennedy men, and even John, the one they called John Jr., there was so much awful, awful stuff. It was really, really bad. I wouldn't go near I wouldn't go near that family. She was obsessed with the Kennedy. I was obsessed with them, with um the whole assassination and everything. The reason I was is because my grandma, who I absolutely adored, I mean, just my absolute safe space in the world. I miss that woman every day of my life. She had a picture of him up on her wall, and I remember her like stroking the cheek of him and saying, because I was asking her, grandma, who is that? And she's like, isn't he she told me who he was, and she's like, isn't he a handsome devil or something like that? And I was like, I don't think he's handsome, but okay, grandma. So I mean, all this stuff happened long before I was alive, but I was obsessed with it, I think, because of that. Like, whatever my grandma did was just like so wired into my brain, and so I became obsessed with the whole conspiracy of his assassination, and I've watched a million documentaries. And but after after that book, I feel repulsed now when I see these people. Like, even I remember when John Jr. died, and I was like, man, these people can't catch a break. But yeah, it looks like there was some bad stuff even about him. But read that book, or I audible everything. Um and I drive a lot, so I was listening to that when I was driving. A few times I almost had a wreck. I was like, what in the world? Oh, Kenny, I can't wait. Kenny says I finished my Milk Jugs parody. I'll never live that down, getting those lyrics wrong. Let's see. A virtual tourist says, even if Blake couldn't change it, if things were fair, Blake would be saddled with the MJOP at the same time as the depositions because it is an adversarial system. So wayfarers should have every right. Absolutely. Absolutely. Oh, she wanted to be a Kennedy. Yeah, I don't think that name has the respect it used to carry. I had watched the story of oh my goodness, what's Bobby's wife? She just passed not long ago. Ethel. I had watched the story of Ethel's life that was made by their youngest daughter, Rory, who was born after Bobby died. And I really liked that, but that was about her. And yeah, but I mean, I thought they were like these great guys because they fought for equal rights. And I think without them, it wouldn't have gone as far as it did, as fast as it did. And unfortunately, or not unfortunately, but it's funny that it's attributed so much to them, but it was actually bills put forth by him that weren't passed until after he died. And then I think after he died, the nation was in such shock, and just like he got catapulted to like almost god level. And so Johnson, who took his place and wasn't as well liked, he got them passed, I think, in order to help his own reputation and to get the love of the people by getting that in place. But I don't know, now I'm getting so far off topic. Claudia says, if you need a recap on the Kennedys, catch the Dark History episode Bailey Sarian did on them. Oh, I like her. Isn't she the makeup lady? She does makeup and tells stories. Is that her, or am I confusing her? Glow, thank you, Glow. The sister who they put in an asylum, yes, because the dad, without the mom's knowledge, he took her to have a lobotomy. She had, we don't really know exactly what her mental health issue was, because things just weren't really accurately diagnosed back then. But some doctor came up with the idea of, oh, give him a lobotomy. So when she was younger, it was easier to deal with, but they said as she went through puberty and got a little bit older, she got a little wild and much harder to handle. And so she he took her to get a lobotomy. And I don't know what year it was, but brain surgery back then was really, really tricky. And he ended up making her basically a vegetable and locked her away. They told people, excuse me, they told people that she was teaching somewhere, that she went somewhere to teach kids or something like that. She was working with kids somewhere. But actually they put her away. And not only did they put her away, they put her away somewhere really far, somewhere in the Midwest, and never visited her. And then as the kids, like the older kids didn't know where she was. And then as they got older and discovered it, they would go visit her. But this poor girl just got abandoned and spent the rest of her life in some faraway care facility. But yeah, it's really, there's so much. Yeah, Kennedy curse. Christina says she also does murder mystery and makeup. Bailey did. Okay, that's what I thought. That's what I knew her from. I forgot about her. I need to go back. But that's the word, Gigi. That his death made him a martyr. That's what happened. He got his position not even honestly. It was power, wealth, privilege, and beauty. And you're right, it was so, so corrupt. And then his death made him a martyr. People forgave all of the awful things that he did and glorified him so much just because of the way in which that he died. I don't think even so. M. Russell says, Cassidy, please, why can't Justin request a recusal of Liman for conflicts? Judge Glanville was recused during the trial of Young Thug's case for one single ex parte meeting without defense's knowledge. Oh, goodness. That's a huge deal, actually. An ex parte meeting. That's really bad. Without their knowledge, especially. Yeah, there's, of course, heat. So I think when it comes to Lyman, there's not like one specific thing that you can say, like this, for example, that it's unquestionable that he's done something wrong. I think it's a collection of little things that each one by themselves, you couldn't say that this is recusal material. He has to recuse himself unless it's something huge like this. And this judge probably agreed with you. I don't know this case. I don't know what happened, but he probably went along with it, and that makes it a lot easier. If a judge says no, heck no, I won't go, it's really, really hard to do anything about it. Federal judges are very, very protected. But on the other side of it, I don't think anyone wants to do that at this point because it's going to put the case they're gonna have to start over so many things, to have so many things overruled. I think it's easier to let it play out and then appeal it if it ends badly. The bad thing is appeals are not always taken. It's kind of a low acceptance rate. You have to have a really, really good cause to get things appealed. In this case, I mean, just my uneducated guess is that they could get an appeal for this case, but it would be so complicated to start over with a new judge at this point in the case. Let me see. Virtual Tourist said LBJ had a tough act to follow, even with how much I don't like JFK. JFK was not his brother. Bobby was the guy we lost with his death, not Jack. Yeah, Bobby did so much more, and he JFK didn't have a moral compass, and as long as Bobby was there, he kind of gave him a little bit of one, and he was behind the civil rights stuff much more than JFK was. Yeah, that's what I uncovered. Thomas says FBI tapes of mafiosos indicate that it was known that JFK was a marked man. I saw that stuff. That's when I really deep dived into the whole conspiracy stuff. And there was a trip he had taken before Dallas, and there were recordings of people talking about how to get him there. At least that's what I saw. I don't know if that's verified, but one of the guys who was really big on uncovering the conspiracy case. I forgot his name. He just passed this year, but he was on a lot of the documentaries and he had so much insight into that. He also was a consultant to this Ellen Greenberg case. Are you guys following that? This woman was stabbed 20 times. She was stabbed in the heart. She was stabbed in the back of the head, in the back of the neck, 20 times. And it was originally ruled a homicide by the medical examiner. And then it was changed to a suicide. But there's connections between the fiance who found her and the local law enforcement. A judge, I think, is his uncle. And it all got changed. And then the family has been having a fit saying our daughter did not kill herself. Our daughter was murdered. And so they've had all kinds of independents come in and look at it, and he was one of them. And I mean, it's sad to see him pass, but I was excited to see that he was still contributing to cases and that he offered his wisdom into this. There were some really high level forensic people that looked into the autopsy and all of this stuff. It's crazy that because some of the things they said is like the heart wound that was fatal. She couldn't have. Well, obviously, I mean, I'm talking about stuff that's probably going to get my video marked as bad. But the knife was still there. So that was the last one. But there was something done to the back of her head that would have incapacitated her. It would have been very, very painful. So it's, according to these experts, they say there's absolutely no way she could have done this to herself. Physically impossible. And so that case is super, super interesting. But he took part in that shortly before he passed. Thank you again, Glow. Tilted Lawyer said it's too late. Yeah. Yeah, it's not going to happen. I think an appeal is coming. They just want to get as much as Lively's mess out of the way as possible first. And he really wants the evidence out there to prove that he didn't do this. Absolutely. Oh, and Lena gave me a recording of how to say your name. So I've been practicing it, but I'm not there yet. I will get there one of these days, and I'll be so proud of myself when I do. I have trouble with names always, but in another language, it's gonna be, um, even harder. I took, like, half a semester of not half a semester, half a term of French a long time ago, and I don't remember it. I did Spanish and then Chinese. So I don't re I didn't I mean, I was learning basic words. I was nowhere near getting the accent correct. M. Russell says, "Thank you, Cassidy. I'm starting to question how Judge Lyman keeps getting assigned to all these cases with such obvious conflicts. I don't think the assignments are as random as we think." You know, that's another thing I meant to look into because it seems like he gets a lot of Hollywood cases. And another unverified thing that I read is that I knew that his father was a high-level attorney in New York, but I read that he represented some Hollywood people. Again, that didn't come from me. It's not verified at this point. And then the brother ends up being a Hollywood director. And I covered like his brother's entrance into Hollywood and how it was affiliated with Harvey Weinstein. And really that's what gave him his start. And so and then his brother, Doug, he was behind the TV series Suits, the one with Meghan Markle. And he said that it was based on his brother's legal practice. So they're all together and they're close and into each other's careers almost, it seems like, with this mashup of Hollywood and the legal system. So I've wondered too, like, does he want, like, specifically want these Hollywood cases? How does he end up? So I wanted to go through and see how many he's had and how many other judges have had. Like, is it odd the number of Hollywood related cases that get assigned to him? And I would think that not all judges have this much stock in Hollywood. I mean, that's a risky thing. His stock is doing terrible. He hasn't made money on this stock in years. It's awful. I can't imagine somebody saying this is where you need to put your money. I feel like if you have that much stock in Hollywood, you have some kind of attraction to Hollywood. The normal person, that's not where they're going to put their money. And he has so much in different production companies. It's odd. I think most judges don't have as much stock as him. I thought that was weird when he came into being a judge because he had to disclose all of his financials. And when he did, he had almost $40 million in stock when he came into being a judge. Now, normally you're advised not to put, at least from what I've heard, not to put more than 50% of your net worth into stock because you could lose it. Stock is not anything sure. So if you put more than 50% and something goes bad with it, you can lose everything. So this man had almost $40 million just in stock. Think about that. Let that sink in. He had enough money to invest in this stock, $40 million. We don't know what his property is, how many properties he owns and where and what their value is. We don't know how much cash he has. This man was loaded, absolutely loaded. Now, I don't know how much attorneys make in New York. I've seen like how much Manat charges. I don't know what his wins were, but if we take the principle of half of his fluid net worth, If he only did 50%, that itself would be $80 million. And then again, we don't know what properties he owns. It's how did he get that much money? I don't know. Maybe attorneys in New York make a lot more than I thought they would, but that's always seemed weird to me. Okay, Doug Liman didn't create Suits. Aaron Korsh did, and it was originally about finance. The execs asked him to change it to law, so the part about Liman and Suits is incorrect. So what was his affiliation with it? Because I have a transcript of an interview with him, with Doug Liman, talking about it being based on his brother's law firm. I covered it in an episode before. So I know he had some part because I have the transcript of his interview talking about it. But I don't know if he was the director or what part he played in it. Glow says, with the Taylor Swift hate, now BL called honestly believe that Justin Baldoni is doing a smear campaign against her too. I saw something on Instagram about a podcast he did that he had Scooter Braun, and they were just like ruthlessly ripping him to shreds for it. Yeah, I don't know why the Swifties can't understand that they're not friends anymore. I don't know what Taylor's going to have to do to make them understand. Her spokesperson has come out so many times and said they're not friends anymore, and they're just not getting it. And I was a Swiftie. I'm holding back right now just because when her album was released and there was all this stuff about the song canceled and everything, I was going to buy the album, and I haven't, because I'm waiting. I'm waiting to see. I mean, I know that one little album purchase is not going to do anything. I mean, it's already broken a million records, but that's who I am. Like, if I don't agree with you, I'm not giving you a view on YouTube or putting any money. And I know it has little effect. It's just one, but that's who I am. Like, I will not give my support, even if it's so tiny. And so I'm kind of waiting. And I really, really want to buy this album. So it's a sacrifice to not go buy it. But yeah, I'm waiting to see, because when it came out and people were like, well, canceled's about her and this is about her and she's and this dress is her and this bracelet is her. And I was like, you know what? I'm gonna wait. I'm just waiting. But I've adored her music for a good decade, like since she came out. I'm not the kind of Swiftie that die hard. I don't wear her bracelets, and I don't track her outfits and things like that, like people do, but I do like her music. Glow says, I'm not a Swiftie, but the album is actually good. It is. I love Opalite and Ophelia, The Fate of Ophelia. They're so catchy. No genuine OG Taylor Swift fans are supporting her. It's the new gen and paid PR bots who are being aggressive and repeating same comments on his socials. I agree that it's PR bots. But then it fools a lot of them. So I'm just saying, says, part of why I relate to you, I cannot support things that do not align with my values and morals. Exactly. Regardless of how little effect it makes. Exactly. It's just, I would hate myself. I would disgust myself. So I just can't do it. Thomas says, I used to think Blake Lively was a cute blonde from Tarzana. It's a good thing I didn't marry. Exactly. Kathy says she hasn't listened to her new music. I did. I have Pandora, and she's my main go-to channel, and it's really good. Or Girl Joy 11 says, I'm with you, Cassidy. Once someone has lost my respect, I won't give them my view no matter what. I've unsubscribed from several creators that put down other creators and no longer watch no matter. That's how I am too. I just have this real strong sense of justice and right and wrong, and some things are unbreakable even for me. So I hope at some point I get to buy the album because I really, really want it. But I'm holding back and waiting to see. I I don't usually move fast on decisions. Um, Glow says Blake calling herself a movie a movie star is a riot. I hate when I see people say the A-list actress because a long time ago, and I need to. It was one of my first lives, so it was really, really awful. I need to do a recorded live of it. But I went through Blake and Ryan's actual Hollywood careers because I think when it comes to Ryan, we mistook, a lot of us mistook prolific for successful because the guy is everywhere. He's been in so many movies. And so we all just were like, yeah, he's a big famous successful movie star. But when I actually dove into his career, he has more flops than successes. And before he did Deadpool, and which is why I think he spent years begging to get to do Deadpool, he he was down to one of his roles was an uncredited, like his name was not even mentioned in the credits. His career was dead. And Blake's never really got off the ground. She After she was doing Gossip Girl, and it's funny when you look at her IMDb, it's usually your biggest success that shows up on the opening page. When it comes to Blake, it's always Gossip Girl. She's known for Gossip Girl. That is her biggest success. And how long ago was that? This was a cable TV was it? Yeah, cable, not cable TV. Was it CW? I don't know. I didn't watch it. So this was her claim to fame. And then during the very end of that, she did get really popular from that. I'm not going to take that away from her, but she got to make a couple of movies, and I think her career was about to blast off. But in the meantime, she'd married Ryan, and who just left Scarlett Johansson, who a lot of people say because he couldn't stand that her career was taken off and his was dying. And I think he got terrified that it was going to happen again. So he started just putting baby after baby in her. And that kind of ended her career. And it never really came off again because what happened to her is in the meantime, he does Deadpool. He gets wildly famous. He has all kinds of power in Hollywood. And she thought because she was married to him that she somehow deserved the same level of power. So when she would make a movie, she would take it over. And then she ended up with that movie that has broke a record for how bad it was. The one she did with was it Jude Law? I never saw it. But that was her career. And even with the power that Ryan has, he never did much to help her. He could have invited her into some of his things, and he didn't. He's got his own production company. Why isn't he supporting her and putting her in things? He used her voice only as Lady Pool. And what did she have, like 2 or 3 lines in the whole thing? And then use somebody else because he's the one who actually fat shamed her. Ryan, or not Ryan, Justin was like, "Oh, don't be so hard on yourself. You're fine. Don't worry about that." And Ryan's like, "Ugh, you're not getting in that suit. I'm hiring somebody else, but you can voice it." You know, it's so crazy. But anyway, her getting this role was a bigger deal for her than it was for the movie. This movie was going to be popular no matter what. That book was crazy popular. People were dying for this movie. Anybody this movie was going to make it no matter what. It wasn't about Blake. And people call her an A-list actress, and really Go through her IMDb and look at how many flops there are to her name and how many flops there are to Ryan. But someday I'm gonna remake that video and make it a recorded one where it's put together and makes more sense, because I was like dying, sweating through my clothes. It was one of my first lives, and so it's messy and it's hard to follow and it's long. So I want to redo that one because I think there's a lot of information in there that needs to be, the public needs to see. And back then, I think not as many people were following the case, not as many people were following me. So I do want to come back and go through that again. But we've passed 2 hours, and so I'm going to get messages that it's too long or comments that it's too long. But thank you guys so much, and enjoy the rest of your Sunday. And tomorrow is the day that the judge told Ezra, you have to have this there in the courthouse. So hopefully inner city press and Clark, does anybody know if Clark is on other social media platforms besides Reddit? I would like to see this person and contribute if they're the one that, whoever comes up with it. They got to pay $34 for this plus the downtown trip. So I would like to contribute to whoever's willing to do that. But anyway, thank you to my mods. We have Christina. I think I saw Lena. And I'm not sure if Jane is here. Sorry guys, I was trying not to look at the chat too much. Except for when the recording part was playing, because I lose my train of thought so easily. But thank you guys all for spending your Sunday with me, and have a beautiful rest of your weekend.